Thank you, ma'am, for your kind opportunity. I'm Waisali Tawhid. My ID is 19406711. The topic of my today's presentation is natural justice. In the realm of law, one of the difficult concepts to define and describe is justice. Thank you, ma'am, for your kind opportunity. I'm Waisali Tawhid. My ID is 19406711. The topic of my today's presentation is natural justice. In the realm of law, one of the difficult concepts to define and describe is justice. Though justice is the end of the law, what is justice has the meaning of universal acceptance. This difficulty arises mainly because the concept of justice is based on numerous aspects and many differing viewpoints and perspectives. According to Kilson, the longing for justice is man's eternal longing for happiness. It is happiness that man cannot find alone as an isolated individual and hence seeks in society. Justice is social happiness guaranteed by social order. Natural justice. The application of principles of natural justice is not a new phenomenon in the legal system. It pertains to moral justice and is governed by laws of equity. The principles of natural justice ensure that a justice is mete out to all and not only to one of the parties in a judicial proceeding. In modern jurisprudence, natural justice is construed to include following three procedural safeguards. Nemo debet esse judex in propria causa. No one should be made a judge in his own cause, popularly known as the rule against bias. Ode alterum partem. No one shall be condemned unheard, or let the other side be heard, as well, or both parties shall be heard before taking a decision, popularly known as the rule of the fair hearing. Reasoned decision speaking order. Every decision must be based on reason. Legal status of the principles of natural justice in Bangladesh. In Bangladesh, the issue concerning the legal status of the rules of natural justice has been settled beyond controversy. Various legal enactments of Bangladesh have necessarily embodied some procedural rights, thereby recognizing the legal effect of the principle of natural justice into the entire fabric of the legal system. For example, the Code of Civil Procedure of 1908 and the Code of Criminal Procedure of 1898 have substantially contained various procedural norms which are recognized as the rules of natural justice. In the case of Abdul Rahman and others versus Sultan and others, the court held that the Civil Procedural Code had deals with procedural matters and not substantive rights, and these procedural laws are governed by the rules of natural justice. Apart from this, legal status of the principle of natural justice has been categorically established in the case of Abdul Latif Mirza versus Bangladesh. In this case, the Appellate Division of the Supreme Court has observed that the principles of natural justice is a part of the law of the country. However, it is important to note that the application of the principles of natural justice is confined only to the cases where there is no express provision of procedural law. This position has been clarified by Justice Bodrul Haidar Choudhury in the case of Abdul Rahman and others versus Sultan and others, where he observed that when the matter is regulated by express provisions of procedural rules, there is no scope for introducing a supposed rule grounded on vague principles of natural justice. To do so is to introduce fancied notions in a procedural law which the legislature did not provide. This observation of the case cannot be found to reduce the domain of the principles of natural justice. Problems with natural justice. The first problem of natural justice, the objection from artificiality. Is justice really a natural human excellence? One problem is that justice does not fit the pattern that Aristotle lays out for the other natural virtues. This problem was famously explored by Bernard Williams in his essay, Justice as a Virtue. Williams suggests that the notion of a just action or outcome is prior to that of a fair or just person. Such a person is one who is disposed to promote just distributions, look for them, stand by them, and so on. The second problem for natural justice, the uneasy relationship between lawfulness and fairness. There is a second problem with the interpretation of natural justice as a virtue of lawfulness. If lawfulness is a virtue, then what do we say about fairness? This problem seems particularly acute given the strong association in contemporary moral and political theory between justice and fairness. The third problem for natural justice, the tension between particularism and rules. Virtue ethics is famous for embracing particularism, the notion that judgments about particular cases take priority over abstract principles. One way of understanding particularism is via the priority of the particular. In a modest version, this slogan expresses the idea that our judgments about particular cases play a more powerful role in more deliberation than do abstract principles and general rules. Conclusion. In a social welfare state like Bangladesh, the state has to perform a manifold function to realize the constitutional dream of social, political, and economical justice. Justice is an ideal which cannot be attained without following the due process in every state action. Thus, every judicial, quasi judicial, and administrative authority should adopt such practices and arrive at decisions which are fair, just, and reasonable. Thank you, ma'am.